International Dispute Settlement in Perspective 1. Obligation of peaceful settlement of international disputes. The peaceful settlement of international disputes is a prerequisite to the maintenance of international peace and security. Furthermore, the establishment of mechanisms for settling international disputes is needed to secure the effectiveness of the international legal system, whilst international disputes stem from a variety of factors, such as strategic, political, economic, cultural, and religious factors. Two elements in particular merit highlighting from the viewpoint of international law. The first noteworthy element concerns the interpretation and application of rules of international law in the municipal legal system. Basic functions of law, that is, legislative, executive, and judicial functions, are essentially monopolized by the state authority. In this sense, the municipal legal system can be regarded as the centralized legal system. Under this system, a dispute with regard to the interpretation and application of law is to be settled eventually by municipal courts. Jurisdiction of the municipal courts is obligatory in the sense that it does not rely on the consent of the parties of the litigation, and the decisions of the courts are enforced by the state authority. In contrast, international law is considered as a decentralized legal system, since there is no centralized authority which exercises legislative, executive, and judicial functions. Definition of international disputes. An often quoted definition of international disputes that stated in the Mavromides judgment of 1924 by the Permanent Court of International Justice (PCIJ). A disagreement over a point of law or fact, a conflict of legal views or interest between two persons. The Mavromides formula and its variations have been repeatedly confirmed in the ICJ jurisprudence. However, the time-honored formula appears to be too broad in its scope in the sense that it includes conflict of interest in the category of disputes. If there are always not differences of interests behind international disputes, a mere disagreement of interests does not automatically create a dispute in a legal sense. For example, an exporting country of petrol usually attempts to export it at a high price, while an importing country of petrol has an interest in buying it at a low price. Here there is a difference concerning economical interests between states. Nonetheless, this is not a dispute in international law unless there is an obligation to fix the price of petrol. Further, conceptually, distinction should be made between disputes and conflicts, even though the term dispute and conflict are often used interchangeably. Whilst conflicts are often unfocused and general in their nature, disputes are formulated by way of claims and counterclaims or denials, focusing on specific issues. The next issue concerns the distinction between legal or static disputes and non-legal or dynamic disputes. The distinction between legal and non-legal disputes. The distinction between legal and non-legal disputes can be found in Varnadias treaties. By way of example, Article 16 of the 1899 Hague Convention recognized that in questions of a legal nature, especially in the interpretation or application of international conventions, arbitration is recognized by the signatory powers as the most effective and at the same time the most equitable means of settling disputes which diplomacy has failed to settle. The distinction between legal and political disputes was also reflected in Article 13(2) of the Covenant of the League of Nations. Disputes as to the interpretation of a treaty. As to any question of international law as to the existence of any fact which, if established, would constitute a breach of any international obligation, or as to the extent and nature of the reparation to be made for any such breach are declared to be among those which are generally suitable for submission to arbitration or judicial settlement. 4. The diversification of disputes in international relations. The scope of international disputes is not static but changes over time. Traditionally, the primary focus of international law has been on the settlement of interstate disputes. Given that the state remains the primary actor in international relations and interstate disputes can directly affect international peace and security, peaceful settlement of interstate disputes will in no way lose its importance. At present, however, the emergence of non-state actors in international relations presents novel challenges with regard to the settlement of international disputes between two parties of which at least one party is a non-state actor. In a broad perspective, 4 types of disputes involving non-state actors can be identified. 1. Intrastate dispute between the government and a liberation movement. 2. Dispute between states and natural, juridical persons. 3. Dispute between an international organization and its member states. 4. Dispute between an international organization and individuals. Classification of means of international dispute settlement. Classification of means of the settlement of interstate disputes. Model 1. A single model. International law governing the peaceful settlement of international disputes is not just a random collection of multiple dispute settlement means, but constitutes a system. To understand the structure of the system, this section discusses the classification of traditional means of the settlement of interstate disputes. In this regard, 2 models can be pre-nupsented, a single model and a dual model. First, this model implicitly presupposes that ideally all disputes should be resolved by judicial settlement of